Hello everyone, welcome back to the channel. My name is Varun Kaushal and I am a legal intern at LEXIS and Company. Today we are going to discuss the question, what is plea bargaining and how does it work? Justice ought to not exclusively be done, however, without a doubt, it ought to be believed to be done, and it is guaranteed by speedy justice or convenient judgment. The right to a speedy trial has been ensured by the Indian Constitution as a crucial right under Article 21. However, it stays just in the paper, as in real Indian judiciary is delayed in conveying justice. In India, the circumstance is unacceptable concerning the criminal justice system. The issue of the excess of cases has been perceived by the governing body, and it presented the idea of plea bargaining by the way of Criminal Law Act 2005 to take care of the issue of accumulating of the case and a lower rate of convictions in Indian court. The idea of plea bargaining was not there in criminal law since its initiation. Thinking about this situation, Indian legal researchers and jurists consolidated this idea in Indian criminal law. As the term itself suggests that it is an understanding between the defendant and the plaintiff, numerous nations have acknowledged this idea in their criminal justice system. Now I will tell you about the concept of plea bargaining. It is inappropriate to assume that the idea of plea bargaining was discovered in recent times. It is utilized in the American judiciary in the 19th century itself. The Bill of Rights makes no notice of the training while building up the fair trial practice in the Sixth Amendment. However, the lawfulness of the plea bargaining had continually been maintained there. In the year 1969, James Earl Ray conceded to killing Martin Luther King Jr. to maintain a strategic distance from execution sentence. He at last got detainment of 99 years. More than 90% of the criminal cases in America are rarely attempted. The dominant parts of the people who are blamed for wrongdoing surrender their protected rights and confess. Consistently, a criminal case is discarded in an American court by the method of a guilty plea or nolo contendere plea. Black's Law Dictionary defines the term plea bargaining as the procedure whereby the denounced and the examiner in a criminal case work out a commonly acceptable mean of the case subject to the court endorsement. It ordinarily includes the denounced conceding to a lesser offense or to just one or a portion of the courts of a multi-include arrangement as a byproduct of a lighter than that workable for the graver charge. Plea bargaining is a pre-trial arrangement between the charged and the prosecution where the accused consents to confess in return for specific concessions by the prosecution. It is where a defendant concedes to a lesser charge and the prosecutors consequently drop more serious accusations. It is inaccessible for a wide range of wrongdoing. For example, an individual can guarantee plea bargaining in the wake of perpetrating egregious wrongdoings or for the violations which are culpable with the death or life detainment. Plea bargaining under Criminal Procedure Code in 1991, the 142nd report of the Law Commission of India contemplated the problem of presenting supplication haggling in criminal equity just because. Then the 154th report of the Law Commission of India recommended adopting the policy of plea bargaining for settlement of a huge backlog of cases. At that point, Justice Malimat Committee Report 2003 additionally supported the 154th report of the Law Commission for presenting plea bargaining in the Indian equity organization system. Taking into consideration all these proposals through the Criminal Law Act 2005, Indian Parliament added provisions for plea bargaining by including Chapter 21A in the form of Section 265A to Section 265L in Code of Criminal Procedure 1908, which came into effect on 5th July 2006. It recognizes plea bargaining for cases where the maximum punishment is imprisonment for 7 years, where the offences don't influence the socio-economic state of the nation, when the offences are not committed against a woman or a child below 14 are excluded. Types of plea bargaining. There are three types of plea bargaining, that is sentence bargaining, charge bargaining and fact bargaining. What is sentence bargaining? It involves an arrangement to plead guilty to one of the various charges or less grave charges by the defendant in exchange for dismissal of other or higher cases. For example, a man is accused of murder and grievous hurt. A prosecutor may accept a guilty plea for the grievous hurt with the court's permission in return to drop a murder charge. Now, what is charge bargaining? This type of plea bargaining occurs for getting less severe charges. This is the most basic form of plea bargaining in criminal cases. Here, the defendant admits pleading guilty to a lesser charge in consideration of dismissing greater charges. Example, arguing for homicide for dropping the charges of homicide. And the last one, fact bargaining. This is usually not applied in courts because it is claimed to be against the criminal justice system. It happens when a defendant accepts to stipulate to some facts to prevent other facts from being included in evidence. What is judicial perspective of this? The idea of plea bargaining was analyzed by the Honorable Supreme Court for the first time in Muralidhar Meghraj Loya for the state of Maharashtra. In this, the court held that the thought of plea bargaining is corrupt, or best case scenario, a vital friendishness. The state can never bargain with the charged; it must uphold the law. Thus, open techniques for a bargain are unthinkable, so it ought not to be presented in the Indian criminal justice framework. A conviction dependent on the plea of guilty entered by the blamed subsequently for plea bargaining can't be continued. Such a system would be unmistakably out of line, absurd, and would be violative of Article 21 of the Constitution. In the state of Gujarat versus Natwar Harchandji Thakur, the court recognized the significance of plea bargaining and stated that every plea of guilty which is inferred to be a part of the statutory process in the criminal trial, should not be interpreted as a plea bargaining. Ipso facto, it is a matter of fact and has to be settled on a case-to-case basis. Acknowledging the progressive nature of law and society, the court opined that the very purpose of the law is to provide a simple, cheap, and expeditious justice by settling disputes. Now I'll tell you some of the disadvantages of plea bargaining. So, some of the significant shortcomings of the concept of plea bargaining, as is identified in the India, are it is a menace to the right to a fair trial. Including the police in the plea bargaining procedures would encourage coercion. By including the court in the plea bargaining process, the court impartially is challenged. Including the victim in the plea bargaining process would encourage corruption. If the plead guilty appeal of the accused is denied, then the accused would suffer great difficulty to establish himself as innocent. To conclude, plea bargaining is for sure a debated concept. Some people have embraced it while others have rejected it. Plea bargaining certainly speeds up caseload disposition, but it does the unconstitutionally. Perhaps we have no other alternative but to utilize this procedure. The criminal courts are too overburdened to approve each case to go on trial. There is a necessity of spreading awareness among litigants, prosecution agencies, police, and general police to make this system more effective, and there should be a thorough study of its working and its impact on conviction and crime rate, and how the system should work properly. To make this more beneficial and to fulfill its aspired objectives, there is a need to amend the provisions to cope with disadvantages or criticisms and to proceed with the contemporary necessities. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and please don't forget to like, share, and subscribe our channel Lexcliq.